Welcome to the Author Interviews for Liberty Matters, a forum of various authors and texts available on the Online Library of Liberty. The Online Library of Liberty is part of the Liberty Fund network of websites. For more information about Liberty Fund, visit our webpage at www.libertyfund.org. I'm Pat Lynch, a senior fellow at the Liberty Fund, and today I'm joined by Michael Greve, who has written one of the response essays for our December 2020 forum on A.V. Dicey. If you'd like to watch any of the other interviews by the authors from this forum or any of the other interviews in this series, please visit our YouTube channel. A link to the forum itself is on the Online Library of Liberty is also on our YouTube channel. Michael Greve is a professor of law at the Antonin Scalia Law School at George Mason University and the author of The Upside Down Constitution, published by Harvard University Press in 2012. He's also has been a frequent contributor to Liberty Fund's webpage, Law and Liberty. Michael, thanks a lot for participating in this forum and for joining us on the author interviews today.
Glad to do this, and thanks for the invite.
It was great. It was a fun forum for me. I learned a lot. I actually wanted to start, this was something that just I've been thinking about this morning. I wanted to start a little bit with one of Judge's assertions in his essay is that Dicey sort of won the long-term battle because he is so widely cited. Now, you are the only member of this forum who actually teaches at a law school, so I thought I would ask you, how much is Dicey recognized, cited, and discussed at contemporary law schools these days?
You know, he has an audience, but for various reasons. I mean, his direct bearing on contemporary debates, I think, operates at sort of one remove. So if you give me a minute, that there are actually two pieces of this. And I'll somewhat simplify this to not turn this into a federal court seminar. So the way Dicey thought about the rule of law was, I mean, the rock bottom proposition with which he started was, in matters of private right, people have to have access to an independent court. And what he meant by matters of private right is what common law judges would traditionally recognize as such, okay? So that's the baseline. That was the sum and substance to him of how the rule of law operates and what characterizes it. Now, for various reasons in the United States, we've gotten very, very far away from that because what the doctrine says is that so long as Congress has power to regulate some subject matter, anything having to do with commerce, it has power to organize and dictate the way in which these kinds of claims against the government then have to be adjudicated. And that may mean that you get an administrative forum, okay, instead of an Article III court. This is the so-called doctrine of public right. There's a big, big, big debate about it. Lots of efforts to reformulate that doctrine because it has these horrifying consequences that just about anything is a private right and there's hardly anything left that really has to be adjudicated by Article III courts. Ironically enough, those turn out to be bankruptcy proceedings. That cannot be right, and people are rethinking this, and sort of Dicey remains a lodestar, but again, that was 100+ years ago, right? And so you have to, you know, rethink an awful lot of American jurisprudence if you want to undertake that enterprise. The other piece of Dicey that's here relevant, and this is what Judge Glock's piece is about and what this exchange is about, is the way Dicey thought about it is, okay, so now these claims run against the government or its officers, okay? And how do we think about that against the backdrop of a baseline of sovereign immunity, which says that you cannot sue the government without its consent? And the way this worked in England, as well as in America for the first 100 years of our existence, is there were so-called officer lawsuits. That is to say, you sued the officers in their individual capacity on a common law theory. And if they exceeded the bounds of their authority or failed to perform a non-discretionary duty, they were on the hook for relief. The French system worked very differently. Basically what the French did, the way Dicey describes it at least, and I don't know enough about French administrative law of the 19th century to tell you whether this is entirely accurate or not. But the way he describes it is the government effectively indemnified the officers waived sovereign immunity, as we would say, and then permitted lawsuits against the government itself. Okay, and so you substitute the government for the individual officer defendants, or what would otherwise be the officer defendants. Dicey thought that was just a horror show. It incentivizes the officers to go rogue and makes relief very uncertain. And then these claims were adjudicated, as he describes it, in courts that were less than fully independent, although over the course of 30, 40 years, he changed his mind about that and described this very, very differently. So that's the general backdrop. I'm not sure that Dicey was entirely right about everything he said, but that's the sort of general backdrop against which this debate unfolds. And as with access to independent courts, we've gotten very, very, very far away from the legal traditions that Dicey embraced in England and here, right, of officer lawsuits. There's now an awful lot of water under the bridge. And if you want to rethink that stuff too, again, you have your work cut out. It's not just this, that, or the other isolated precedent. It's over 100 years of jurisprudence that has gone off on a very different track.
So you make 2 points, that one of which I want to explore a little later on, but the one that I think is a real strength of the essay is your review of how the U.S., when it was first established under the Constitution, that there were a number of these suits against individuals, and that the Congress eventually decided to move away from that. Can you walk our viewers through, if they haven't had a chance to read the entire exchange in the forum yet, exactly what happened in the U.S. to sort of move Congress and move the United States closer to that administrative law system where essentially it's suing the government, not the individuals?
Yeah, so that was a fateful step. And it all unfolded largely in the context of litigation over railroad rate setting. Okay, somebody has to set the rates, at least so long as you treat them as natural monopolies. It can't be the courts, right? It can't be Congress itself. So it's got to be some kind of executive body of some description. Okay, and so what the Congress tried to do at the front end was to keep the courts involved. The courts themselves insisted on getting involved in, very deeply involved, mind you, in reviewing the fairness of these rates for constitutional mistakes, takings, and due process claims, and so on and so forth. And over time, that became much, much more attenuated. And the underlying theoretical problem is this. The problem with these officer lawsuits is they're feast or famine. That is to say, so long as, once the officer steps outside the lines of his or her authority, legal authority, you get full-scale judicial adjudication, no questions asked, right? And that sounds, hey, great, that's positively Diceian, right? That's what you want. The glitch comes, what happens when there are statutes that give that give public officers enormous discretion? That is to say, there's a big grant of authority and they have discretion as to how to exercise that. And what the officer lawsuit model said, and this is still to a large extent sort of the baseline of British administrative law at least, you get no relief at all because courts cannot review the reasonableness of the officer's actions. Because if they did subject that to what we call full-scale judicial review, the courts might as well be the executive. And so you want to treat those kinds of decisions as political matters. It's left to the executive. Congress meant it to be left to the executive. And under an administrative legal system that grants, enormous discretion left, right, and center, that's really kind of a scary process or project, right? And so what the courts did at one end was they undertook somewhat deferential review of administrative discretionary actions that later became codified in the Administrative Procedure Act. That's what we call arbitrary, capricious abuse of discretion. And on the other hand, they throttled back a little on, the standards that apply to the review of whether government acted within its legal bounds. And so all this collapses into this administrative law Malay that is very, very far away from, from the way Dicey envisioned the world.
It's yeah, I mean, your essay is definitely, shall we say, less sanguine than Judge's hopeful, a slightly more hopeful essay would be in this matter. It's interesting you talk about the range of the discretion. That struck me as something that came out in your essay, because you were discussing the case of the quasi-war the United States was engaged in with France in, I believe, 1804, if I'm not mistaken, if I recall your essay correctly.
Yeah.
And you had American ships flying under Danish flags who were sneaking, excuse me, back and forth in and out of French ports. And you cite the case of the captain who was given a U.S. naval captain who was given a very, very vague order. Is part of the difficulty here the natural tendency of the government to provide wide discretion to its officers and to not be specific enough, or is there just a delegation problem here? Is there just a problem, a principal agent problem here that makes this sort of problem that we would seem to be pretty simple that Dicey's trying to tackle on just not very feasible in the real world because of the nature of governance, or is it because of the expansion of the state in the 19th century that it becomes untenable?
I think it's the latter, right? So at some level, look, let's go back to the case that you mentioned. It's called Little versus Perrine, okay? And what happened there, Congress wrote a statute that was just unadministrable, right? So, you could seize the ships that go in one direction, but not the other direction. Out there on the open sea, how on God's good earth is the commander supposed to tell where they're sailing from or to, right? And so the Secretary of the Navy said, now here's what we're going to do about this statute. If you have a reasonable suspicion, do all that lies within you to enforce the statute as well as it will be enforced. And then Captain Little makes a genuine bona fide mistake, right? He acted on reasonable suspicion. You had no way of knowing where this beast was sailing, whether it was a false flag or not. Nonetheless, they put him on the hook for damages. And John Marshall did this with a very, very heavy heart, but said, no way, no how. Now, even in the 19th century, there are cases actually that go the other way, where the courts all of a sudden start saying, whoops, there's got to be at least a subjective good faith defense in these kinds of cases, right? If the officer really had no way of knowing, and if he acted in good faith, then we'll let them off the hook. The law on this stuff is messy. I haven't read all the cases, but it's kind of murky. What I think is driving this at a later point, at least to my mind, is the growth of the state, the routinization of government decision-making. I mean, all of a sudden you have, gargantuan benefit programs, workers' comp programs, insurance programs, right? Where it's really, really hard to say that, no, wait a minute, this is all for Article 3 courts, you get full-scale review. Nobody wants that, right? And so you have to figure out a way how to sort of, at least keep this within reasonable legal bounds. There are a whole lot of decisions that deals with it, but at least as a functional matter, that's the way the world worked and how this developed. And then the next step of it, mind you, is the gargantuan explosion of constitutional claims beginning in the 1960s under the Warren-Brennan court, where all of a sudden, the Bill of Rights gets imported hook, line, and sinker into the 14th Amendment. All of it, all of a sudden, with few exceptions, holds good against the states. The states and cities and towns are getting sued left, right, and center for injunctive relief, for damages, and on and on and on. And so to put a little damper on that, the court cranked up the courts, I should say, cranked up these official qualified immunity doctrines that are the principal subject of this exchange.
So if I can ask, this is a sort of, I guess, a theoretical question. If the expansion of law has been so substantial, I think you and I can agree it has been. I think any reasonable historian of U.S. constitutional or certainly the U.S. government, the U.S. legal code would agree with that, whether it's a normative claim or not. Then all of a sudden the officers are not really are not the reasonable target of these claims. If they're put in untenable positions, then the government itself or the legislature should be the ones who are held accountable for this, if I'm thinking clearly about it. Or maybe I'm just thinking like a theorist and not an attorney.
No, so that there are, Patrick, there are various questions there, several questions, right? So on the one hand, you may want to say that we want a legal regime, and this is actually a very Dicey-an notion, that effectively deters each and every individual officer from unlawful conduct, right? It's the deterrence function that you really want out of this. This is why, for example, Dicey thought there could be no general supervisory liability in these kinds of cases, right? Because that would just give the lower level officers an excuse and saying, hey, I was just following orders. Well, Captain Little could have said that. He was following orders, right? But that didn't count under that system because you want the deterrence function and the compensation function. Now, with respect to the deterrence, there's a lot of literature on this stuff. And mind you, I mean, there are endless empirical studies about how 1983 litigation works and what it does in real life. It turns out in nearly 100% of all cases, the officers are indemnified by their agencies, right? Either by their agencies and the institutions that they work for, or there's some insurance scheme that indemnifies them against these kinds of claims. And in that case, you wonder, I mean, how much deterrence are we actually exercising here, right? And the other problem that you rightly point out is the fear that the officers might be put into an impossible position. I mean, they frequently have to act on the spot, right? They don't have any time, you know, when there's a riot out there to consult the law books as to exactly what are they supposed to be doing and what are they allowed to do. And so it's for that reason that the courts have this test that says it has to be objectively, I mean, in order to be compensable, and mind you, to be very clear about this, we're only talking about money damages here, right? Injunctive relief, don't do it again, that's a totally different question and works differently. But before we say somebody's on the hook for money here, we want to know that this conduct was objectively unreasonable, okay? And the officer should have known it. There are lots of problems with that test, but the intuition is exactly yours, which is, come on now, I mean, these officers, excuse me, are frequent. We operate with a general presumption that they act in good faith. Of course, we want to weed out the bad apples, but we can't, you know, start the legal inquiry with that kind of an intuition, right? We have to start with the opposite intuition. You know, by and large, they try to do the right thing and they're put in very difficult positions. And so we want a legal regime that protects them, not just from the damages down the road, but from having to stand trial in the first place. That's what the official immunities are designed to do. They operate at the front end of these proceedings.
So we're kind of straying into discussions of police activity, but these things extend now to almost all officers, as I understand, all officers of the executive branch. Am I correct in that regard?
Yeah. Yep.
Okay. And so the consequences of this are not merely police officers who stray. So in some instances, we're talking about, in the case of police, people who face, or the military. And as Judge points out, you know, one of the initial development, or one of the initial causes of Dicey's interest in this was when Mill called out the governor of Jamaica for his actions during the slave uprising there, where many dozens of people were killed, if not hundreds. I'm not familiar with the specifics of the history, but there's also, if I'm listening to you correctly, there's a wide range of instances in which government officials are indemnified, even if they're not forced to make these kinds of split-second decisions that involve life or death. This extends across all sorts of instances with the executive and the bureaucracies.
Yeah, so it depends on the precise statutory framework, right? So the Administrative Procedure Act, which governs federal agencies, generally doesn't allow claims for money damages. That's handled under very, very different statutes. I'd be happy to explain. I mean, I don't know all of them.
I'm very disappointed to hear that, Michael.
Yeah, I mean, excuse me, but mind you, many of them import the same rules that obtain it's the same qualified immunity rules that we've been discussing, which frequently come up in the law enforcement process, you know, cops and police and police and so forth. But the indemnification schemes, as far as I understand, they're pretty comprehensive, right? So it's very, very rare that you find individual officers on the hook for money damages where they physically have to pay.
So are these these are privately indemnified by insurance companies, or these are just indemnified by the government?
Sometimes, and generally it's the government itself that indemnifies the officers under some statutory scheme.
Okay. And do the states generally apply the same standard, or are we talking more? Okay, so the states are similar in this regard. Yeah. So in your essay, you talk about how we got to this position, and you are a lot less hopeful than judges that a Dicey solution gets us all the way there. What is your argument? Can you sort of summarize your argument about how we would get there through? I mean, I guess what you're suggesting is that to shrink the state, it's going to have to be a legislative decision, not exclusively a judicial decision, to get us to the point where we move away from these sorts of problems within the legal system.
That is a very, very good question, and a very, very hard question. So let me, spend 2 minutes arguing with myself, okay? Because
take your time. Take your time. I'm sure you could argue with yourself for much longer than 2 minutes. So
I'll try to make this brief. So you could say, on the one hand, now look, these qualified immunity rules that we have now, which cover all officers with the exception of prosecutors and judges, okay? Those have absolute immunity. But everybody else. We've had this regime now for the better part of 5 decades, okay? And for federal officers, we've had it since 1971. Congress has legislated repeatedly against the backdrop of that understanding. That's how, these qualified immunities effectively got imported in a lot of subsequently passed statutes. It has never done anything at all about the scope of 1983, of Section 1983 actions, which are that's the basic federal statute enacted in 1871 that serves as a basic vehicle of enforcing constitutional and federal statutory rights of a certain description against states and local governments, okay? It's never done anything to overrule the courts. And so from that vantage, you may want to say that, look, these are statutory interpretation decisions, okay? And the general rule is that we adhere to stare decisis, to decisions once made, right? On the theory that Congress can always overrule us if it wants to, and if Congress thinks we got something wrong here, okay? So that's one argument that says, no, leave this to Congress, okay? So that's one side of the argument. The flip side of this argument is that there are certain statutes which the Supreme Court calls common law statutes that it has read as an invitation to the courts to develop the law in a common law fashion, okay? The most famous example, or the clearest example, is the Sherman Act, the Sherman Antitrust Act, right? Which the court has read as an invitation to the judiciary to develop law on its own. And there the court has been very, very cavalier about its own precedents and said, well, that was all ours to begin with, and so we're free to overrule it if we change our minds, right? And without that, there would have been no antitrust revolution ever. And 1983 arguably is that kind of a statute, that is to say, it's so broad that you want to understand it as an invitation to the courts to develop the law in a common law fashion. If you take that line of argument, then you may want to, you may be tempted to say official immunities are wholly judge created. We now realize that that was a mistake. And so it's incumbent upon us to rethink this and change it. Even if the precedents are 50 years old and there are certain reliance interests around them and so on and so forth. We now realize we made a mistake. The situation has changed very dramatically on the ground. There are good reasons to approach this, excuse me, as a matter of judicial prerogative and duty and obligation. And I can on that argument either way at you.
So what's interesting, if we can extend this to what's been going on in the country over the past 9 months or so.
Yeah.
If we extend this out, then the argument may be something like this. So while it is popular to say we need to reform police departments or we need to reform the way that government officials are acting through changes in what's broadly now called qualified immunity, and this gets thrown around quite a bit, by local legislatures or state legislatures changing rules. But what you're suggesting is that may not be sufficient, that the judiciary itself, and you say this in your essay, that the judiciary itself, the preponderance of whom in the higher courts have gone to places like Harvard and Yale and these sorts of places, have been steeped in this tradition in which the court or the judge or the judiciary is free to legislate over various areas, and that's going to have to be a culture change in addition to a legislative change?
Probably, I'll say this on an optimistic note, or at least a moderately optimistic note. It is, it's actually amazing to see the extent to which people at reputable law schools, Chicago,
well known, well prominent. Let's say prominent. I'm not sure about reputable.
Okay, fine. Prominent law schools are willing to rethink this. And mind you, the rethink started, before these incidents, the riots and police brutality over the past summer. Although obviously that lends sort of a certain amount of salience to what started out as an academic debate. And there are hints here and there in Supreme Court opinions. Justice Sotomayor has said, I'm willing to rethink this. Justice Thomas has said, in an appropriate case, I want to rethink this entire edifice, right? Now, they've said that for very different reasons. Okay, among other things, Justice Thomas has a somewhat more lax attitude with respect to stare decisis than many other justices. He has a much greater respect for what did this actually mean at the front end than many other justices. So that's probably how he would approach it. Justice Sotomayor may have a much more functionalist approach. I don't know where the rest of them stand on this. But this is a live debate. This is no longer academic speculation.
So would you speculate on whether or not some folks are going to return to Dicey as some kind of a starting point for understanding the theory behind this, or is he someone who we're going to see referenced less and less in these potential changes?
I don't know the answer to this. I will give you the sort of broader answer. You cannot rethink and I made this point in my sort of observations there, brief as they are. You cannot rethink the sovereign immunity problem in isolation. I misspoke. The official immunity, qualified immunity problem in isolation. It's entangled with all kinds of other questions, including at one remove, sort of the prevalence now of administrative adjudication, which somebody may want to rethink because that's really, now becoming a grave point of concern. And you certainly want to rethink doctrines that allow these broad claims against government in the first place, right? So the biggest example out there is 1983 gives you relief or a claim for relief, for monetary relief, if the state actors acted under color of state law. And it turns out what the Supreme Court took that to mean is that, hey, there's a cause of action and, you know, a claim for relief, even if what the officers did was manifestly unlawful already under state law. So they can't have acted under color of state law. But that's what most of these claims are now, right? Yeah. And so it's because of these broad claims and where states were left in the position of saying, now, look, we did what we could to prevent this and to tell the officers you can't act like that. And then they're still on the hook, right? It's because of that weird situation that the Supreme Court handcrafted these official immunity doctrines. So if you want to rethink one, you have to rethink the other. So it's not an isolated problem, right? And so on that note, I mean, on that note, a further note of caution for the Supreme Court to disentangle that amid the vagaries of litigation. That's really a tall order. Somebody would have to have a halfway coherent strategy. You'd have to do it one step at a time. Could I draw you that, you know, on a whiteboard? No, I wouldn't know how to do it.
But it's interesting. It sounds as if Black Lives Matter needs to think about creating a legal team to take these claims to the Supreme Court to start this discussion, as well as protesting.
You know, that has started. It's just fiendishly hard because 1983 litigation has become a graveyard. I mean, the Supreme Court has handed down, you know, I don't know. There's a law review article out there that counted all of these decisions, including summary reversals of lower court decisions by the Supreme Court. With one or two exceptions, all of them, all Supreme Court decisions have gone in favor of sovereign immunity, yet another mistake, of qualified immunity. And the lower courts, by and large, have, you know, gotten the message. And so either these claims settle out, which is frequently the case. I mean, the settlement volume in these kinds of cases is very, very large. You know, or else they get dinged on qualified immunity grounds pretty quickly. Okay, so that stuff, I mean, it's not as easy as one thinks. It's a minefield out there. To flip that around, there are now libertarian litigants who are trying to make a go of these kinds of cases.
Interesting. Well, on that somewhat cautiously not completely pessimistic note, is that a fair way of saying it? It sounds like we've got a lot of work to do in order to be able to change this. But Michael, thank you for taking some time out of your very busy schedule to talk with us. I appreciate your contribution, and thank you for sitting down to talk with us for the author interviews at Liberty Matters.
It's been fun, Patrick. Thank you.
Thank you.